And as a consequence, I will also try to make the introduction short. We have a large panel, and that's not a comment about size. Let me just get to the introductions, and other people can wander in. And I will skip an introduction of Jeff Breinholt because he's already been introduced, and that should suffice. Incidentally, this is supposed to say Robert Strassfeld. That's who I was earlier this morning. I will just point out that Jeff may be right that there was no musical scene in Northeast Ohio, but we did help to give birth in the 1970s through the band Devo to New Wave, for good or for bad. And Jeff will be talking about empirical results, efficacy of the Bank Secrecy Act. To his right is Professor Carlos Japiassu, who is a professor of law, an associate professor of law at the State University of Rio de Janeiro. And I will let you read his biography for all the other details. And he isn't. You played a trick on me. He's 2 people down, but he's on my list as speaking next. And he is also the Deputy Secretary General of the AIDP. And are you going to be speaking second, or have you folks changed?
No, it's order. Yeah. Well, actually, yeah, it doesn't matter.
Okay. He will be, when he speaks, he will be talking about combating terrorist financing, the South American experience. In between is Bruce Zagaris, who I also will skip an introduction to because he has already been introduced. I have him listed as going forth. They'll sort out the order. Talking about international standards and process. Next to last is Jack Smith, and he is formerly the Deputy General Counsel of the FDIC, and I, again, will leave to you to read his interesting and varied biography. And he will talk about developments in asset forfeiture. And finally, at the end of the table is Professor Jimmy Gouroulet, who was recently the Undersecretary of Enforcement in the United States Department of Treasury. He is now Professor of Law at Notre Dame, and he will, I guess we call that Notre Dame in this country, and he will be talking about U.S. criminal prosecutions, and I will now get out of the way in the interest of getting the panel on the road.
Thanks. I'm only going to talk for about 5 minutes, and I want to first say, don't assume that because of what appears to be acrimony among speakers and things like that, we don't like each other. These are very good debates, and we all know each other, we all like each other, and where I come from in law enforcement, a debate is really not a debate until writing utensils are thrown, and there has not been a writing utensil thrown yet, so that's sort of what I'm used to. I'm going to talk for about 5 minutes because you've heard enough from me today, I think, today, and I'm going to give, I hope, to those bankers out there something that is real and deliverable. I would describe it as being part bad news and part good news. Part bad news because I think it might frustrate some of the industry reforms that are at issue right now. But some good news because I think I figured out a way, or I think we figured out a way, based on ththese studies, to give you guys what you want, which is what I frequently hear when I do industry meetings, which is more information in a more timely way and more feedback. So let me just tell you what this is. This is something the FBI very rarely gets complimented on. This is public. Anybody who wants this PowerPoint, send me an email. This was the subject of some congressional testimony by the former head of the Terrorist Financing Operations Section, a guy named Michael Morhart. The FBI does have trained empiricists working in their industry rank, in their special agent ranks. And these people, I joke around, are part computer. I mean, they're people who've been working in the private sector in database management. And they also come from a tradition of empiricism in that some of them were hard scientists before they went to the academy. And the study was this. How can we assess the quality of currency transaction reports that are between the $10,000 and $30,000 range? And the reason this is important is because there's an industry push right now to raise the CTR triggering amount from $10,000 to $30,000. The argument being $10,000 today doesn't mean what $10,000 meant 25 years ago. And inflation has taken over that. So let's raise the CTR requirement, probably the most automatic, mechanical type of Bank Secrecy Act compliance, because it doesn't involve discretion. Let's raise it from $10,000 to $30,000. And Congress is very interested in this because they could do it by regulation. And so it could be done without an act of legislation, but Congress is very interested in their oversight. And so the question became, how do we test that? How do we test that? And they came up with a methodology that I think is just fascinating. And it sort of, I think in terms of analogies. And it's very similar, if you think about it, to what type of thought process or what type of methodology you would want if you were in charge of giving advice to a governor of a state. Say you're a safety transportation official, a highway state officer who is going to give advice to the governor. And the question is, you have two tolls along a state highway. And let's say that you feel like you can double the toll at the second of these two. And you could eliminate the first one. The question is, what would you lose? And how would you go about testing whether or not that would be a good idea or a bad idea? And if you think about it, what you want is, you want to know how many people go past the first toll and then get off the road before they get to the second toll, right? That's what you want to collect. That's what you want to see exactly to make enough. If not many people do, you simply double the rate of the second one and eliminate the first. You eliminate the employee, eliminate the employee's job, or the structure. You can take that off, and people who drive on those roads will be happy, presumably. That's pretty much what the FBI did when it came to CTR requirements. They wanted to find out how many good CTR filings are between the $10,000 and $30,000 range. Okay? Question is, what is good? How do we decide what is good? And in the intelligence world, when people talk about intelligence being good, there's a term they use. It's called pertinence. And you hear about somebody, some CIA person who's increasingly they're going on TV, and they say, I had all sorts of pertinent intelligence, blah, blah, blah. Pertinent means something you can act on. These are things that the consumers of the intelligence want the collectors to give them. That's pertinent. That's the holy grail of intelligence. How do we define good CTR filings? And this is what the FBI said. They said, let's take all the CTRs that have been filed and match them against people either by name or by social security number of people we already know about because they're already a subject of an FBI investigation of any sort. These are people who are current subjects of FBI investigation, money laundering, counterfeiting, identity, terrorist financing, money, everything. And if the CTR filing qualifies as a match, it means that the bank is giving us some additional information about a person we're already interested in. So that was the definition of pertinence. Okay? Here's the entire universe of CTR filings. If you add this up, you'll see that about 72% of all CTRs between 2000 and 2005 are between the 10 and 30,000. Now, this doesn't tell us anything. All this says is there's a lot of compliance in the industry, and that about 3/4 of all CTRs. Now, if we raised it, we'd simply lop off 3/4 of those CTRs, without being completely agnostic as to whether or not those are good or not good, pertinent or non-pertinent. Okay. Here's the overlay. This is their methodology. Here's what we find. Okay. If you add this together, it's about the same percentage. So about 72% of CTRs that are pertinent are between the $10,000 and $30,000 range. This is not, I would submit, this is not good news for those who want to raise the CTR reporting requirement. We're going to lop off not only a lot of paper, but a lot of good paper if we do this. Okay? The upshot of this, and this is what Mike Morhart testified, the practical effect on law enforcement activities of an increase to the CTR threshold reporting amount would be to severely limit or even preclude law enforcement access to financial data associated with cash transactions that are not otherwise documented. These are cash transactions, after all. You might get it from the bank statement, but they're not a check. They're not a wire transfer. So that's the bad news. Here's the good news. Imagine if we did this. Imagine if we took the same methodology and isolated all of the pertinent SARs. Okay? SARs, as you know, have a narrative. Okay? So if we can isolate the universe of pertinent SARs that are filed for a period, those are people that banks have told us they are suspicious about. Banks tell us why they're suspicious in the narrative form. What prevents us from taking that data out, putting it into a database, crunching it, and sending out indicators? We don't know why, but these are indicators of people who you filed on that we have under investigation. This is what our investigative subjects are doing with you guys. I think this is a way of giving real-time intelligence to bankers. Because remember, this would not be linked with any individual. This would be just general types of red flags that you've given us. From our review of your information, those that are pertinent, this is what they're doing that gave rise to suspicion. That's step one. Step two, and I'm very vocal on this point. It is now time. Uh-oh. Somebody didn't like this. It is now time to think seriously about giving bank compliance officers security clearances. You think it's controversial? It's particularly controversial now because the telecoms are being sued and they're trying to negotiate immunity for acts of helping the FBI after 9/11. And so the industry, I'd say a year ago, the industry was saying, of course, Lockheed Martin, Boeing, all the defense contractors, SAIC, they all have clearance. Why can't we do that with bankers? Bankers, after all, a lot of them are former law enforcement who have had security clearances. It would not be hard to do a reinvestigation. What's holding this up, in my opinion, is the political season. And I think this is a no-brainer. I think we should do it on a pilot project. We'd have to negotiate a protocol so that the banks would be very clear about how they can handle that information. What would happen is the banks would get together and they, just as industry players, would be promoting their overall creativity in developing algorithms that could help us go after things that we see. So with that, I will turn it over to the next speaker. Thank you.
Well, good afternoon. Just skipping Bruce, then we'll go back to him. First of all, before I start, I'd like to point out certain things. The first of all is I would like to ask you to forgive me for any misuse of English. Coming from Portuguese-speaking countries, not that easy to speak English in a conference like this, but I have to say it's normally a problem because I have noticed that no one speaks Portuguese but us, and Bruce is the American. It's well known in my country as the American lawyer who speaks Portuguese. So.
You sound Brazilian.
I'm sorry.
I said you sound Brazilian.
Yeah, maybe. Another point to this subject, I have to say that if we're talking about international criminal law, international criminal aspect, I'm coming from a country who has lots of difficulties in this field. It means Brazil is, I can say it's a big country, but it's not in the center of the international criminal discussions. If you talk about terrorism, we're certainly not in the center of the discussion of the matters. Today we've been the whole day discussing and listening to aspects with U.S., EU, Middle East, but not a word about South America, not a word about my region. So surely we're not in the center of this discussion, and it necessarily creates a problem. We had a lot of difficulties to accept international standards, international measures. So for us, I'm talking not only for my country, but the continent as a whole, it's being normally international rules has been seen very frequently as, I can say, a foreign intervention, not necessarily a well-accepted rule. I've been working this last month in the Well, I work as an international criminal law professor. In my country, I tend to say I'm talking about something no one wants really to listen there. Besides, I've been working in the recent months in the Ministry of Justice. I'm a full counselor of the National Council for Penitentiary and Criminal Policy. So this is the organ, the Ministry of Justice, responsible to formulate our criminal policy, to suggest international criminal matters. It's not that easy, I can assure. Saying that, what I have planned to discuss with you today, as I'm not in this, my country is not in the center, and I can say South America as a whole is not in the center of this discussion. I have planned to show how these international rules has been reflected in our national legislations. It means how the national legislation in this region has accepted these international rules regarding the combating of terrorist financing. For this purpose, I have chosen to examine the legislation of 4 countries, probably the main important in the region. It means Argentina, Chile, Colombia, and Brazil. They have different perspectives in this subject. I'll ask you to present this. I had forgotten to say, but for me it's a great honor to be here. I'd like to thank, of course, Richard Gordon. I'd like to thank Case Western University for the fantastic work they have done these days. And of course, I'd like to thank the American section of the International Association of Penal Law for bringing, I guess, for the first time, AIDP event to the U.S. It's something for us that work in the National Association of Penal Law can say something historical. I hope we'll have in the future, in the near future, more events here. But at least for the first time, it's a great pleasure to be here. For me, an AIDP event is always an extraordinary occasion. The association has devoted all its life since its foundation in Paris in 1924 to the study of criminal matters. I should point out right away that the discussion of the international criminal law has been a fundamental theme for the AIDP since its very beginning, and the association, through the efforts of some of its members, maybe the main known in the U.S. is Sheriff Passioni, our former president for 15 years, has played an important role in the debate of this subject. Furthermore, there has been a process of internationalization of criminal law over the last decade with the adoption of new international instruments in penal matters, a consolidation of what has come to be called the global prohibition systems, as in the cases of money laundering, terrorism, and terrorist financing. In my continent, the recent borders conflict in South America due to the activities and consequent repression of the so-called Revolutionary Armed Force of Colombia, FARC, reputed as a terrorist organization, brings special importance to this subject in the region I came from. So it seems pertinent to reflect on how terrorism and its financing have been dealt with in South America, as a way to evaluate the work in progress of international initiatives towards the combating of international terrorism. My presentation will be organized as the following. First, I will talk about terrorism in South America, and as an example, I will discuss the legislation of 4 of the most important countries in the region. As I said, Argentina, Colombia, Chile, and Brazil. Later, I will make an overview on the measure related with development and enforcement and asset seizure in the South American region. Talking about terrorism in South America, I can say that the phenomenon of terrorism has been the object of jurisdiction provision within South American legal systems since the decade of 1920s, nearly a century ago. At that time, following the European models, for instance, Brazil adopted legislation to address cases related to anarchist terrorism, which had repercussion in Brazil primarily through the influx of Italian immigrants. Although previous models can be found in the continent, the terrorist phenomenon has gained importance in the 1960s and 1970s, especially for the so-called leftist movements that tried to combat military governments whose dictatorships were a common characteristic of the region in the period. Additionally, during the period of the military governments, spanning the years from 1960 until 1980s, terrorist attacks occurred that were instigated both by elements opposed to the dictatorial regime as well as modalities that have come to be called state terrorism, attacks perpetrated through the action of government authorities. It can be said that the most important aspect of terrorist movements at that time was certain ambiguity, which means that the modality used was frequently the urban guerrilla and not the traditional forms of terrorist attacks. Most of the countries of the region have in a certain way experienced some terrorist activity in their territory in the last decade. Otherwise, after the establishment of democracy, these activities have lost importance. As examples of terrorist organization, it can be mentioned the French patriotic Manuel Rodrigues in Chile, that in the early 1990s has attacked some American companies. As its members have considered themselves as anti-USA, they have attacked 2 McDonald's and 1 Kentucky Fried Chicken restaurants. In a few time, this group has become specialized in killing policemen, bank robberies, and attacking Mormon churches. It can be said that the Chilean state repression have partially finished this group. One of the most famous terrorist groups in the region was the Peruvian Sendero Luminoso, that was founded in 1960 and in the 1980s became one of the most violent terrorist groups in the world, being responsible for more than 30,000 deaths throughout the years. Probably the most known case of terrorist movement in South America is in Colombia. The Ejército de Liberación Nacional was originally founded in the 1960s and is well known for ransoms, kidnappings, and armed attacks on Colombia's infrastructure. Initially, it was not only a Marxist group, but also based on the liberation theology. Recently, Colombian President Álvaro Uribe invited ELN spokesman Francisco Galán for new talks about peace on April 3rd, 2008. It was said that the ELN will return to the negotiation table. The most famous terrorist and guerrilla movement in South America is the so-called FARC, that is self-proclaimed Marxist Leninist revolutionary guerrilla organization. The FARC is considered a terrorist group by certain governments, such that the Colombian and the American. Otherwise, countries like Cuba and Venezuela refer to that leftist rebels as insurgents. It was established in 1960 as the military wing of Colombian Communist Party. While the FARC originated as a purely guerrilla movement, the group is said to be involved with the illicit drug trade during the 1980s, which caused an official separation from the Communist Party and the formation of a political structure it calls the clandestine Colombian Communist Party. The FARC is present in 15 to 20% of Colombia's territory, most strongly in the southeastern jungles and in places at the base of the Andes Mountains. Its main known activities, the taking of hostage, especially I think the most famous hostage in the world is the former presidential candidate Ingrid Betancourt, that is quite frequently in the newspapers and television nowadays. On March 1st, 2008, the Colombian military conducting an operation against guerrilla camp inside the Ecuador territory killed Raul Reyes, the FARC international spokesman and considered to be the FARC's second in command, along with at least 16 of his fellows. This incident led to a breakdown in diplomatic relations between Ecuador and Colombia and between Venezuela and Colombia. This is considered the biggest blow against FARC in its more than 4 decades of its existence. This event was quickly followed by the death of Ivan Rios, another member of FARC's top leadership, less than a week later by the hands of his own forces as a result of heavy Colombian military pressure. Despite of this, it can be said that nowadays South America is not a region characterized by terrorist attacks, except by certain specific events, such as the bomb attacks to the Israeli embassy in 1992 and to the Associación Mutual Israelita Argentina, AMIA, in 1994, both in Buenos Aires. On the other hand, the Colombian situation seems to be the most difficult one because it still has terrorist and guerrilla activities going on, and peace negotiations do not seem to be sure. Even worse is the fact that FARC have activities in other countries of the region, such as Ecuador, Bolivia, and possibly Brazil, that may cause higher tensions. Just to inform, I don't know if it was noticed here in the US, but something like 15 days ago, the Brazilian army has announced that some Brazilian soldiers has killed certain FARC members in Colombian territory. So they had entered Brazilian territory, Brazilian soldiers had followed them and killed them in Colombia. It was not, I think, the diplomatic question, just because the Colombian government are not very, I can say, pleased with FARC activities. But I don't know if this kind of activities can generate tensions in the region more important than the ones we have today. Another problem that has been debated is the tri-border area between Brazil, Argentina, and Paraguay. It is said to represent a problem regarding financing of terrorist activities, despite the fact there are no recorded cases there. So it normally is said to have problems there. There are the Arab community in Brazil and that region is one of the most important in the country, more Lebanese people. But until today, it's not. We have no evidence that it's really any case of terrorist financing there. About legislation against terrorism in Argentina, Brazil, Chile, and Colombia. As mentioned above, I examined the legislation for the main South American countries. This choice was made for two reasons: the importance of these countries in the region and the fact that some of them have recent legislation against terrorism. Meanwhile, Argentina, Chile, and Colombia have more recent legislation on this subject. Brazil has a 1980s law. Considered that the later is the biggest country with the largest population and economy, this different approach can show a part of the problem that measures to combat terrorism and its financing may face in South America. In 2007, the Argentine Congress has passed legislation on terrorism and terrorism financing. Law number 26268, so-called, the law against illegal terrorist association and terrorism financing, entered into force on July 4, 2007, and modified the Article 213 ter and quater of the Argentine Penal Code in order to criminalize acts of terrorism and terrorist financing and establish terrorist financing as a predicate offense for money laundering. Due to this change, now the penalties for terrorism are prison sentences to 5 to 20 years, and those convicted for financial terrorism are subject to 5 to 15 years sentence. This law is being heavily criticized in Argentina, as some may say that it is just a way to adopt the American Patriot Act as a model law to the continent. It means that the Argentine law is viewed by its critics as a model to obtain effectiveness, but to lose certain constitutional rights. In Chile, Law 314 from May 16, 1984, and Law 906 from November 13, 2007, intends to criminalize terrorist financing in that country, provide sanction to terrorist financing in conformity with the UN International Convention for the suppression of the financing of terrorism. Under Law 906, financing of terrorist act and the provision directly or indirectly of funds to a terrorist organization are punishable by 5 to 10 years in prison. The Superintendence of Banks circulates the UN Security Council Resolution 1267 sanction committees consolidate lists to banks and financial institutions. it has to be said that until now the Chilean government has not identified any terrorist assets belonging to individuals or groups named on the list in Chile. Some critics say that the law enforcement lacks tools to investigate terrorist financing. Undercover operations, for example, are not permitted in Chile for such investigation. In Colombia, terrorist finance is now an autonomous crime. The law 1121 from December 30, 2006 amended the Penal Code to define and criminalize direct or indirect financing of terrorism of both national and international terrorist groups in accordance with the Financial Action Task Force of South America and Egmont Group recommendations. The new law allows the Financial Information Analyzing Unit to receive suspicious transaction reports regarding terrorist financing and freeze terrorist assets immediately after their designation. In addition, banks are now held responsible for their client base and must immediately inform of any accounts held by newly designated terrorists. Banks also have to screen new clients against the current list of designated terrorists before providing prospective clients with service. It can be said that Colombia has a more comprehensive legislation regarding terrorist financing in the region. At the same time, that it is the country which has more direct challenges involving the combat of terrorist organizations. On the other hand, in Brazil, currently, the law addressing terrorists is Law 7170 of December 14, 1983, known as the National Security Law, which established under Article 20 that punishes an individual who destroys, sacks, extorts, robs, kidnaps, imprisons, burns, plunders, causes to explode, makes a personal attack, or perform acts of terrorism due to political non-conformity, or to obtain funds to be used to support the organization of a political or subversive nature, or who establish, join, or maintain an illegal military organization of any type or nature, armed or not, with or without uniforms, whose purpose is to engage in combat. It must be highlighted that in South America there is a straight connection between drug trafficking and terrorism, especially in Colombia, and the Brazilian criminal system recognizes. The Brazilian new law on drugs, number 11343, adopted in 2006, has created a new offense to cover up this issue named drug trafficking financing. So this provision can be used to punish terrorist financing if it's connected to drugs as in Colombia reality. For example, if any act related to the financing of the FARC occurs in Brazil, the national legislation on drugs can be a basis for punish terrorist financing with high penalties, from 8 to 15 years imprisonment, as drug trafficking financing offense, since there is a connection between the two crimes. Besides, there has been no specific law ever since to deal with specifically with terrorism and its financing, which create difficult to effective implementation of measures to combat it. I'm not going to have certain things to develop, but due to time, I'll leave some for the debate. But just want to say that, as you may see in South America, the combat of terrorism and terrorist financing can be analyzed in different ways. While Colombia, for its own situation, has a more proactive behavior with a comprehensive legislation, other countries have more internal difficulties to pass national legislation on the subject. Even in the case that there are recent legislation, there are still too many internal criticisms. Those different approaches may generate problems to internal cooperation in criminal matters, even to regional cooperation. So possibly it's time to discuss the need to harmonize criminal systems in the region, even knowing that a lot of difficulties may arise. I'd like to thank you very much for your attention, and I'll be open to discuss a little more after.
Okay, good afternoon. I'm just going to focus on a few points because it's late. I also want to thank the organizers, both of this conference and also of the AIDP session. I want to talk about the important role of international treaties and also the international process, the involvement in the role of the private sector, I think I'm going to skip my third topic of the enforcement in light of the new FATF report. But anyone who's interested, you're welcome to my slides. And then talk about the need to assess progress and consolidate before embarking on new areas. In terms of international treaties, the best means to enforce terrorist financing and asset forfeiture measures are multilateral and bilateral treaties. We've had some talk earlier about the importance not just of the UN Financing Convention, but all the other treaties such as the UN Vienna Drug Convention, the Anti-Corruption Treaty, and of course the Palermo Treaty against transnational organized crime. And all of them have a very similar pattern. And one of the things that's important is when law enforcement is, wants international cooperation, instead of just citing bilateral treaties, I think whenever possible, they should also cite the multilateral treaties so that law enforcement around the world can get accustomed to the fact that they are hard law and they impose obligations. In addition, regional treaties can be important to supplement them, such as in this hemisphere, the Inter-American Convention Against Terrorism. Also, the Security Council resolutions are important. And as Jeff has mentioned, because of the limited membership and big power politics associated with the Security Council, and asset forfeiture and enforcement regimes can best be developed through a rich mixture of hard, such as treaty, and soft law measures. A limitation in implementing effectively the terrorist financing and asset forfeiture mechanism is the limited capacity and resources of the participants. Participants are stretched to even effectively fulfill international anti-money laundering standards such as the 40 recommendations. As most of you know, in 2006, the FATF did a complete review of the recommendations, and they broadened the scope of the recommendations, including the persons that are included. In my opinion, the international community and also the governments and the private sector have not had the capacity to implement even the revised AML standards, let alone the counterterrorism financing and more recently the nuclear non-proliferation standards. However, one very important development has been that all of the hard and soft laws have now made in all of the countries the establishment of a financial intelligence unit, which there wasn't before. And also now we have the Egmont Group, which has been formalized, and as a result of the Canadian government stepping forward, the Egmont Group has a headquarters in Toronto. And this has been a very important development in terms of harmonization of enforcement institutions throughout the international community. It's difficult doing all of the standards through FATF, since, as we've heard, FATF is just an informal group, has no legal personality. The World Bank group has, and especially the IMF, has filled the void, but recently the IMF has suffered a major reduction in resources and also has limited capabilities in the AML, counterterrorism, financial arena. Similarly, large and medium-sized countries are struggling to effectively implement all the requirements, and the private sector is struggling to understand many of the AML concepts, such as the many products, whether it be PEPs, private international banking, and correspondent banking arrangements, all of which require, of course, enhanced due diligence. On top of that, they must impose new counterterrorism financing standards, and also the nuclear non-proliferation due diligence. And in the United States, we're about to be hit with new internet gaming regulations, even though the international community, namely the World Trade Organization, has said that they're illegal. And indeed, we're about to have likely a new complaint filed in the WTO by the EU as a result of the discriminatory prosecutions of their organizations, their companies, whereas in the US we don't see certain people that are doing internet gaming, namely the horse racing industry, they're getting a free pass. In the US, the private sector must also implement, at the jeopardy of criminal prosecution, unilateral sanctions on entities such as narcotic kingpins in various jurisdictions that have been declared terrorist jurisdictions such as Cuba, Syria, and so forth. The financial institutions must purchase and maintain separate AML and CFT hardware and software and human resources. What's happening now is, as a result of the unilateral efforts by the US private sector is starting to disproportionately suffer their ability to compete. I mean, you really see this, for instance, clearing transactions. I mean, London loves that the problems of clearing transactions in the US, because of the possibility that maybe one of the 10 or 20 or 30 persons involved are going to be on the list, it is going to make the transaction not be cleared, and it could be hung up for 5, 10, even more years. And so companies are just simply clearing in London or even now Singapore. And to the extent that asset forfeiture is done on a unilateral basis, such as the US OFAC regime, the cost of forfeiture and enforcement actions are borne disproportionately by the US sector. Also, when transactions are done in sensitive geographic areas such as the Middle East, some advisors caution against using US financial institutions, both because of the US unilateral sanctions, but now they also caution because of the dollar. And so again, US financial institutions are having trouble competing. I think that a more important dialogue and at an earlier stage has to occur between the international community, namely the international organizations, and the private sector. Okay, in closing, the other thing I want to focus on is a reassessment. Before the international community develops new regimes, such as the more recent nuclear non-proliferation financial regulations, it may be useful to ensure that the existing terrorist financing and asset forfeiture enforcement are effective. It is useful to concentrate on improving, for instance, the work of FIUs and their interactions with each other around the world, and also to deepen their effectiveness. In particular, there's a lot of work required to make the assessments, these are the assessments of governments that either the FATF or the IMF now does, effective, fair, and to ensure the proper follow-up, because again, neither the international community nor the governments that receive these assessments are able to effectively do the follow-up. A perception exists among many small jurisdictions, including some of the ones that I work with, that policymaking and implementing processes are not fair because the G8 countries dominate them. And finally, to attain legitimacy, sustainability, and hence effective implementation and enforcement, counterterrorism financial policies must meet proper governance and transparency. And with that, I thank you for your patience and turn it over to, I think, Jack.
Thank you, Bruce. There are a number of tools to combat terrorist financing that we've been hearing about today, and I'm going to tell you about one that hasn't been spoken about very much. Asset recovery. There was in 1992 an Italian anti-mafia commission, you might remember. They were trying to crack down in Italy. One of the witnesses was a mafia don named Gaspar Moltolo. I wrote down what he said because I liked it. He said, you know what really hurts us the most is when you go after our money. We would rather go to jail and sit there with our money than to be free without our money. And so what do we learn from these people? Go after the money. So that's what asset recovery is about. It's been a problem traditionally for international asset recoveries because the victim countries, the developing countries especially, they wanted to have their money back, but the countries that received the money said that, well, you know, it's hard. We have this money in our banks maybe, but we have bank secrecy, and you know, you have to give us a criminal judgment. You have to show us the nexus between the crime and the money. So it's been rather difficult. But the United Nations finally got upset a few years ago when it discovered that 54 countries out of the 190 on this planet had become poorer in the last 15 years than they had been 15 years ago. And they tried to figure out why. And they talked to the World Bank and other specialists, and they found out, you know, corruption, it's stealing all of our money. We have to do something about corruption. So they came up with the United Nations Convention Against Corruption, which Bruce just referred to. The center point of the United Nations Convention Against Corruption is, guess what? Asset recovery. You know, the UN did something right. They figured out that if we really want to stop corruption, we need to get the money, because people are still going to steal the money unless they know we're going to come after it. So the fundamental principle of the convention is asset recovery. And in there, they did everything they could to make asset recovery easier. Here's some provisions just for banks. You want to see how easy it's going to be now? Well, they've got new provisions emphasizing requirements for customer and unofficial owner identification, record keeping, and what have we been talking about? The reporting of suspicious transactions. 140 countries have signed this thing, and it is unbelievable. 111 have ratified it. I live in Switzerland. I'm sorry to say Switzerland is not one of those 111 right now, but I'm expecting them to get on board by the end of the year. Listen to the next one. These countries have to implement measures to enable the identification, tracing, freezing, or seizure of any item for the purpose of eventual confiscation. We're going to be able to get the money back. Bank secrecy, you're still worried about that, aren't you? Remember I said 140 countries signed this? Courts or other competent authorities can order that a bank turn over financial commercial records, and they can be seized, and they can override refusals to give the documents and the assets based on our old friend bank secrecy. Even that falls by the wayside. So what these countries have signed is the most remarkable document to get back the money. Now, why is this important to terrorist financing? Well, just 6 weeks ago, the FATF did a paper on terrorist financing, and it's included in our papers that we got today. And it's very interesting. It talks about, I'll summarize it for you, and we've heard, in fact, they have one of these little lists about these terrorist acts. The Madrid train bombing cost $10,000. The Bali bombings cost $50,000. The U.S. coal attack only cost $10,000. And so you'd say, well, why does it make any sense? You can't go after that little bit of money anyway. Who's ever going to find it? It's going to drift through the bottom of the banks. Well, what this paper makes is a very important point. That amount of money that I just read to carry out those terrorist operations is just the tip of the terrorist iceberg. The big part of the terrorist iceberg is under the water, where you generally don't see it. They spend millions, it says. Funds are required to promote a militant ideology, pay operatives and their families, arrange for travel, train new members, forge documents, pay bribes, acquire weapons, and stage attacks. Often a variety of higher cost services, including propaganda and ostensibly legitimate social or charitable activities, we had such a nice discussion about that already, are needed to provide a veil of legitimacy for organizations that promote their objectives through terrorism. In other words, they spend a lot of money trying to win the hearts and minds of the populace around them. So, let's go get the money. Now, Jean-Francois said earlier that, you know what, there is no magic bullet here. The best we can do is hope to disrupt the activities. That's probably true, but sometimes there is a magic bullet. You might remember a few years ago, we had our own homegrown terrorist organization. It was going back, over 100 years, back to the Civil War days. It was called the Ku Klux Klan, the KKK. Thousands of members, especially through the South. What was the fatal bullet for the KKK? Does anybody remember? Yeah, Civil RICO. We took their money, we took their headquarters and everything else. They were out of business, and you don't hear about them anymore. We can do the same thing. You have to trace the money. Now, we have very powerful tools for the Justice Department to use, and every other country can use these. Civil and criminal forfeitures. You can get not only the proceeds of the crime, you can get any assets used in the crime. Well, if they planned it in their house, you take their house. If they had a business which they funneled the money through, you take the whole doggone business. You take their boats, you take everything they have. Gaspar Motolo would be crying with all of this, I tell you. And don't forget, the United Nations Convention made money laundering all by itself a criminal offense. And to do this, you've got to engage in money laundering. Bribery is another criminal offense. They bribe people right and left. We can get the money. And what does 18 U.S.C. 233(9)(b) say? Well, it's a crime to provide material support to designated foreign terrorist organizations. Sounds like any charity that provides support. We can take down the whole doggone charity. And everybody who contributed money to it, knowing what they were going to do with the money. So how do we find the money in this day and age? How do we trace it? Nikos, where is he? He's gone. He said they have these hawalas. You know what? He was right about one thing. We shouldn't drive the hawalas out of business. We shouldn't drive them underground. We shouldn't tax them into oblivion. Let's bring them up and let's have them provide the information that we need. And in fact, a lot of the evidence that has been gained for terrorists, including the Bali bombing, is through hawalas. So let's make them more efficient at it. What about these cash couriers? You know, they're transporting money across borders on donkeys and camels and things. How are we going to get that money? Well, that's what customs are for. I mean, the pharaohs back in the Egyptian days had customs. It was on their tombs and tablets. It's so important to have honesty and good customs officials, because otherwise people will escape taxes. Well, FATF Special Recommendation 9 says, all right, let's beef that up. Let's have measures to detect that. Let's have declaration systems. Let's get our customs systems doing the job. What did Deep Throat say? Follow the money. If we can take down Tricky Dicky by following the money, we can follow the money and get these guys. Computers, email records. What happened in the case Carlos was just talking about? Here's Colombia going across the border and taking out this terrorist group. What did they find? A computer. Well, you know, it had information on it. financial information. It said that Venezuela was giving these rebels money. You know, if I was the Attorney General for Colombia, I think I'd have a real good case against Venezuela before the International Court. I think that's worth about $1 billion, just that one computer, if anybody's here from Colombia. Now, all of this, of course, depends on international cooperation. And that has been dropping the further we get from 9/11. Now, there's an article that appeared just 2.5 weeks ago in the LA Times. And I cut it out so I could read it. And you see, I highlighted it. So many interesting things and so many interesting people quoted. It said, the most serious problems have come from fractures and mistrust within the increasingly fragile coalition of nations that the United States admits it needs to target financiers of terrorism. Well, we got to do our homework on diplomacy. We got to get George Bush going. Well, maybe he's already exhausted his credits. Well, maybe we got to get the next president going on this. He or she has got to get out there and stroke up the diplomacy. We've got to get our friends and relatives across the oceans to help us on this. And why? Well, the article makes it clear that the Saudis haven't even established an accredited financial intelligence unit yet. In Kuwait, terrorist financing is not even a crime yet. In the UAE, there's been not a single conviction for terrorism or money laundering yet. So these people are not coming to the table. And that's a diplomatic problem, and we need to fix that. And I hope the next president will fix that. Now, this asset recovery stuff can be very profitable. You remember Ferdinand Marcos from the Philippines? Well, what they say he stole, I don't know. You never recover everything. These people lose a lot of money on foolish investments. But there's $658 million we got back. Got it out of Switzerland and the UK, Liechtenstein. What about Vladimir Montesinos from Peru? $174 million got back. What about Sani Abacha from Nigeria? $700 million we got back there. And all of this within the last 4 or 5 years. So there's money out there that we can get back if we follow the money. Lastly, people haven't even figured out you can get even more money back if you want to know how profitable this is. In the savings and loan scandal of the 1980s and 1990s, you know where the FDIC got most of the money from that it recovered? Aiders and abettors. You don't even think about that. Who's helping these yo-yos invest their money and hide their money? Accountants and lawyers. What did Judge Stanley Sporkin say in the Charlie Keating case? Well, how could all this happen? Where were the lawyers? Where were the accountants? Well, they were right there in the middle with that guy, and we sued every one of them and got big payments back from them. And so, what we should do against this thing, if we can find out a way to do it, is follow the money. And what you're going to have to do to make these criminals, these people who are financing terrorism, you have to make them afraid. And so I thought about the most fearsome creature on the planet, and we have to sick these guys on them. What we're going to do is we're going to darken the sky with lawyers.
No, not that.
All right, Jimmy, take it away.
Okay, thank you. First, I'd like to take this opportunity to thank Case Western Reserve University School of Law, the Institute for Global Security Law and Policy, and AIDP for sponsoring this very important conference on combating terrorist financing. As you're obviously aware, we've had a very lively discussion today on a number of issues. And while we may disagree on some of the issues and how they should be handled, I think that there are at least two things that every speaker that has spoken here today agrees on. And the first thing is and Jack emphasized this, going after the money. He talked about the operation cost. There's been a lot of emphasis and discussion about the operational cost, but he emphasized, and I'll reiterate, the importance of the organizational cost. With respect to Al-Qaeda, prior to September 11th, 2001, the FBI estimated that Al-Qaeda's annual budget was approximately $30 million a year. That's not an insignificant amount of money. That's a year. Every year it needs $30 million, or at that time needed $30 million to support its organizational infrastructure. We turn to an organization like Hamas. It's been estimated that Hamas's annual budget is anywhere between $100 and $150 million a year. And then with respect to Hezbollah, I've seen figures that their annual budget may be as much as $200 million a year. So the long and short of this is the inference to be drawn from those numbers is despite what people say about, well, it doesn't cost a lot of money to commit, to perpetrate, to initiate a terrorist attack, it does cost a lot of money to terrorize and to run terrorist organizations. So going after the money, I think, is a very effective and an important strategy. And it does have value. I think it can deter, it can disrupt, it can prevent terrorist attacks, and it can make it more difficult for these organizations to operate around the world. And we are talking about organizations that have a global, international reach. It's been estimated that Al-Qaeda has terrorist cells in as many as 60 countries throughout the world. It costs money for Al-Qaeda operatives to communicate, from senior leadership to communicate with these organizations. The propaganda campaign that's alluded to in the FATF report on terrorist financing, very important for Al-Qaeda for recruiting new members. And they've developed a very sophisticated internet propaganda mechanism for communicating its message. The second point that I think that every speaker who's participated in the conference would agree is that the task of combating terrorist financing is an extremely difficult one at every level. And we've covered a lot of ground here. There was one panel that discussed the financial regulations and monitoring of financial transactions, the filing of SARs, very difficult. Another panel that talked about the alternative remittance systems and hawalas that move money globally, very difficult. We've had discussions about the designation process, both at the UN international level and at the U.S. domestic level, very difficult in terms of dealing with public source information, classified information, what information can you disclose, the legal challenges that have arisen in the United States, in the EU, and elsewhere, very difficult. And of course the issue of charities, because certainly no one wants to prevent money from going to legitimate humanitarian causes. But even if that's the case, we can't permit some of that money being diverted to finance terrorist organizations like Al-Qaeda and terrorist activities. International standards, another difficult issue, whether it's the FATF 40 recommendations or the 9 special recommendations, very difficult. And lastly, and the subject that I'm just going to spend about 5-10 minutes talking about is enforcement. And like these other areas, these other components of the overall global strategy on terrorist financing, criminal enforcement actions are not unique. They're also very difficult. They're very difficult cases to make. They're very difficult cases to prove. And my research has concluded that the Department of Justice has a mixed record. They've had a very difficult time making and proving major, and I underscore major, terrorist financing cases. And just to give you a little bit of history here, I think it's fair to say that prior to 9/11, prosecuting terrorist financing was not a priority for the United States, was not a priority for the Department of Justice. I have not been able to find in any published court opinion a pre-9/11 terrorist financing case. Now, that doesn't mean that the Department of Justice was asleep with respect to prosecuting terrorism cases. It was doing that. It prosecuted the perpetrators of the 1993 World Trade Center attack, the first World Trade Center bombing, and it was successful. It prosecuted the perpetrators of the terrorist attacks on the U.S. embassies in North Africa, in Kenya, and in Tanzania, and it was successful in achieving some important convictions. And there are other cases as well, important terrorist cases that were prosecuted. But those cases involved the perpetrators. Those cases involved the planners, the plotters, the persons that actually implemented and launched the terrorist attacks. They were not terrorist financing cases. So we're talking about a relatively short history here with respect to terrorist financing prosecutions, and it's about a 6.5-year period post 9/11. And Jack alluded to one of the principal statutes that was enacted by Congress to prosecute terrorist financing cases, and that's 18 U.S.C. 2339B. That criminalizes providing material support, including financial support, to something called a foreign terrorist organization, or an FTO, and it's a term of art. The organization has to be designated by the State Department as being an FTO before it's a crime to provide financial assistance or some other form of support to such an organization. So it doesn't cover every terrorist organization, only those that have been designated by the Secretary of State. And the other major terrorist financing statute, there's actually 3, I'm just going to focus on 2, is 18 U.S.C. 2339A. This statute is a little different from 2339B. This also makes it a crime to provide material support, but here the focus is on anyone who provides material support knowing or intending that the material support go to facilitate a terrorist crime, the commission of a terrorist offense that are enumerated in the statute. So it's not limited to these designated terrorist organizations, FTOs. So those are the principal, at least 2 of the 3 principal statutes enacted by Congress. To date, there have been several, since 9/11, major terrorist financing cases, but unfortunately, the Department of Justice has not been successful. In fact, they've suffered a series of significant and somewhat embarrassing legal defeats. Bruce spoke briefly on the Holy Land Foundation case. I mean, that was a major terrorist financing case. It was promoted, if you will, highlighted by the Department of Justice as a major terrorist financing organization. Holy Land Foundation and the former directors and officers of that charity, with being the principal fundraising arm for Hamas in the United States. And the claim was that it had raised millions of dollars for Hamas, $13 million or more. As Bruce correctly stated, that case resulted in acquittal of one of the defendants and a hung jury on the other defendants. Having served as a federal prosecutor and a state prosecutor before I became a law professor for approximately 9 years, and having prosecuted major narcotics cases, organized crime and narcotics cases, it's incredibly rare for the Department of Justice to take a multi-defendant case charging multiple counts. And by the way, in this case, there were approximately, I think, 50 or 53 counts in total that were included in the indictment. And the Department of Justice left the courtroom after the trial with not a single conviction against a single defendant on a single of the 53, 54 counts. It just doesn't happen. It's extremely rare. Now, perhaps I wouldn't be so concerned if that was the only case where the Department of Justice has failed to convict in a major terrorist financing network. But you probably heard of and read news accounts of a case that took place, a trial that took place in Florida, in Tampa, involving Sami Al-Arian, the South Florida, former University of South Florida professor, who's a professor at that university. And again, the Department of Justice brought an indictment against Al-Arian, Sami Al-Arian, and several co-defendants. And again, the claim was that this organization was raising millions of dollars for Hamas-related terrorist groups. Again, the jury came back after deliberating for several days, no convictions, not a single conviction. All of the Al-Arian-related defendants were acquitted, or the jury could not reach a verdict. It was a hung verdict. Now, after that, in fairness to the Department of Justice, Sami Al-Arian did plead guilty, but it was to an immigration violation, not a terrorism charge. And the agreement was, I think, time served, and then he agreed to be deported. But certainly one couldn't point to that and say, well, that's a great victory. You know, we got him on an immigration charge. When again, it was, I think in that case, 39 counts against 7 or 8 defendants. And again, but for that conviction that he pled guilty to an immigration count, the government left empty-handed. A similar result in a case involving Mohammed Salah out of Chicago. He was alleged to have been a conduit for Hamas and fundraising in the United States, allegedly handled hundreds of thousands of dollars, transporting hundreds of thousands of dollars to the Middle East for the benefit of Hamas. He was charged under the material support statute, and the jury acquitted him on those charges. He was convicted of a much lesser charge, an obstruction of justice charge, for lying, committing a false statement, perjuring himself in a civil case involving terrorism brought by the victims of a terrorist attack. Their son was killed in a terrorist attack in the Middle East. But I don't think you could look at the Salah case and say, well, that's a real victory. We got him for the obstruction of justice charge. When again, the leading charge was a material support, the conspiracy to commit material support violations, and so on. And then lastly, the Benevolence International Foundation case involving a defendant by the name of Anam Arnaut, the former executive director of the Benevolence International Foundation, or BIF. BIF is an Islamic charity. It's listed on the UN Consolidated list. It's also on the OFAC list. And I remember when that indictment was publicized. Then Attorney General Ashcroft traveled from Washington, D.C. to Chicago to participate in a press conference with Patrick Fitzgerald, the U.S. Attorney in Chicago, to announce this important indictment against Biff and Arnaut. And again, there were material support counts that were included, RICO counts that were included, RICO conspiracy counts that were included. I mean, some very, very serious, significant charges. It was either the day before the trial or the day of the trial. Arnaut and the government agreed to a plea bargain, a plea agreement. Arnaut agreed to plead guilty to a RICO conspiracy count, very serious charge. But every allegation related to Al-Qaeda, and in this case was an Al-Qaeda case. Sami Al-Arian and the Holy Land Foundation were Hamas-related cases. BIF was an Al-Qaeda case. The claim in the indictment was that BIF was being used to raise money for Al-Qaeda. Every reference to Al-Qaeda was removed from the plea bargain, and every reference to the word terrorism was removed from the plea bargain. So basically, what Aronow pleaded guilty to was fraud on donors, on charitable donors. And what he admitted to was approximately, I think it was about $130,000 worth of supplies, I think boots, blankets, some uniforms, were purchased with charitable donations. And those supplies and equipment were sent to Islamist fighters in Chechnya that were fighting against the Russians for a Islamic State. I mean, it was a battle over establishing an Islamic State in Chechnya. And so basically it was a fraud case. It was reduced from a major terrorist financing case to a fraud case. And, I don't want to dismiss that. I mean, that's significant. But when you read the indictment and you read the press release, I mean, when you read the plea bargain and you read the press release regarding the plea bargain, again, no reference to Al-Qaeda, no reference to terrorism. So for me, the question is, what's going on? As I stated, the Holy Land Foundation case was bad enough. I mean, one case, not even a single conviction against a single defendant on a single count. And then that's followed by the Al-Arian case, Muhammad Salah, the BIF case, and so on. What in the world is going on? Why is this happening? And, I wish I had a good answer for you. I can postulate, offer some suggestions as to what may be the problem. And let me offer a few. I think that perhaps Congress may need to revisit and amend the material support statute. At least one court, the Federal District Court in Tampa, that presided over the Sami Al-Arian case, interpreted the material support statute as requiring specific intent. So in that case, the court said that the government had to prove beyond a reasonable doubt, the jury had to find unanimously that Sami Al-Arian provided money to Hamas or a conduit or an agent of Hamas with the intent for that money to be used to facilitate a terrorist attack. It had the specific intent to kill, in essence, for that money to be used to kill. Well, that's a very, very high standard when it comes to prosecuting criminal cases. It's the highest standard with respect to proving the mental element of an offense. Now, it's interesting, the statute doesn't say specific intent. If you read the statute, it says that the material support was provided to a foreign terrorist organization with knowledge that it was going to a designated FDO, or with knowledge that it was going to an organization that commits acts of terrorism, or with the intent. So you can prove it with knowledge. You don't have to prove it with intent. This judge said no, you have to prove specific intent. So maybe Congress needs to go back and correct the view taken by the court in Tampa, which, by the way, has been rejected by every other court that has considered the issue. Second, maybe there's some lessons to be learned for federal prosecutors with respect to charging cases. As I stated, the Holy Land Foundation case involved multiple defendants, at least 50 counts. One of those counts was a conspiracy count, and that conspiracy count had over 300 overt acts that were alleged. And so the jury had to grapple with finding whether the government had proven beyond a reasonable doubt on each and every one of the 53, 54 counts that were alleged in the indictment. From my perspective as a former federal prosecutor, one could make the claim of overcharging. Why do you need to charge so many counts? Why not simplify the process? Why not charge 5 or 6 felony counts that if the defendant is convicted on those counts, are still going to guarantee that he gets 30, 40 years in prison, which would probably be a natural life sentence for someone like Sami Al-Arian. I think to go to that extreme, that many counts, so many different theories and different statutes that these charges are based on, I think makes it very difficult for the jury. And again, I think it's counterproductive. I think it also speaks to the difficulty of criminal prosecutions, especially when there's classified information. You know, what do you do? And I've been in that position where you're kind of caught in the catch-22 situation. Can I disclose this information? And if I disclose this information, am I going to be jeopardizing someone's life? Not simply an ongoing investigation, but an informant or a government operative who's working undercover. Am I going to jeopardize his life? And then if I don't disclose it, am I going to jeopardize my case? Because the jury's not going to have the benefit of that information. And so that's difficult. And then there's an issue there about how should classified information be handled. And in a way that, of course, comports with due process, both consistent with the Fifth Amendment due process clause of the U.S. Constitution, as well as international human rights standards on fundamental fairness, due process, and a fair trial. But it's a tough issue. There have been a couple of proposals that I'm considering, and I'm not sure that I fully agree, but one proposal, the Council on Foreign Relations has proposed that the administration, that the President established a terrorist financing czar, someone that's in charge of coordinating the activities of, I think the last count, there are 19 different federal agencies that play a role in terrorist financing. 19 federal agencies. And it should be no surprise to any of us here that the coordination with respect to those 19 agencies has not been optimum by any means. In fact, there's been a lot of infighting, a lot of turf battles, a lot of who gets the credit, a lot of who's in charge, all to the benefit of the terrorists, and all undermining U.S. and international efforts to convict Al-Qaeda members and members of the Taliban. So maybe we need someone that's in charge of controlling the catfighting that's going on between and across government agencies. And then there's been a proposal that perhaps we need within the Department of Justice a unit, a section devoted exclusively within the criminal division to prosecuting terrorist financing cases. Now, there's currently a money laundering section within the Department of Justice, but we know that terrorist financing and money laundering are similar in many respects, but they're not the same. And the knowledge and the expertise that's required to prosecute a terrorist financing case, the knowledge of Al-Qaeda, its organizational structure, its history, its operations, it requires a unique skill set. And not every prosecutor has that kind of knowledge or can just pick it up in a matter of a few days. So maybe we need a special elite group of federal prosecutors that are devoted exclusively to prosecuting nothing else except for terrorist financing cases. So those are a couple of suggestions. I don't think that any one of them represents a silver bullet to the problem, but clearly something needs to be done because there is a problem here. We've got 4 or 5 cases within the last maybe 3 years where the Department of Justice has suffered these defeats. So I'll stop there and then open it up for questions.
Thank you. I, with a little bit of trepidation, will invite, because I suspect you do have things to say to each other, we'll invite the panelists first if they want to comment on anything that any of their colleagues. If not, boy, was I that?
We're tired of beating up on each other.
Okay. Well, in that case, we have just a little bit of time for questions in the interest of getting people to planes and the like. But we can take a couple of questions if anyone has questions or comments. Yeah. Just fling it at
So it's the end of the day, so I'll forgive the naivete of this question, but Mr. Smith alluded to the large amounts of money that can be recovered through asset seizure. I'm wondering where my financial institution can sign up to get our hands back in that pot so we can recover some of our costs that we use to monitor for that activity and further improve our monitoring techniques.
I'm sorry, that's a cost of doing business.
I thought I saw another hand there.
Hi. I'm taking the anti-money laundering class here at CASE, which is unique. And I'm doing the assessment for Togo. And one thing jump out is like there's no provision in the law of Togo or any of the West African countries concerning politically exposed persons. So I just want to know what the United States or the international community is doing to pressure those countries to really comply with the 40 recommendation of financial task force. Thank you.
I'm not, can't remember if Togo's one of the 111 countries which has ratified the UN Convention Against Corruption. But there's a provision in the convention that states parties must have those kinds of laws on the books. Now, some countries have not yet ratified because they don't have the laws. They're not able to say that they're in full compliance. That's Switzerland's excuse, incidentally. They don't want to sign until they get all their laws in order. So a lot of countries are doing what's called a gap analysis. What's the gap between the requirements of the convention and their own laws? And Togo should be doing that kind of a gap analysis. And if you're interested in that country, any law professor, if you turn them on to this issue, would love to do it because he's going to get a lot of press and be the expert in that country for this issue. Get a gap analysis and then put pressure on the legislation, on the legislator to get their laws where they should be according to this international treaty.
Last question.
Okay, I'm just wondering about Hamas. Is Hamas a terrorist organization or a political party like Sinn Féin in Ireland? I do believe that there are terrorist organizations, but I mean if Hamas is a political party, then if somebody declared the Republican Party a terrorist organization and made contributions to the Republican Party a crime, wouldn't there be a lot of protest over that?
I can take that. I frequently get asked about why don't we designate domestic terrorist groups like the KKK or the Animal Liberation Front or something like that? And the answer is, I'm not sure we could under our Constitution because we are at the limit of exercising foreign policy discretion in basically allowing, this is what the courts have said, allowing the president in the interests of foreign policy where there's heavy judicial deference to declare certain states and certain entities embargoed and off limits to any person subject to our embargo authority. And so that's the designation process. It's basically the designation process with terrorism means that we've declared an economic embargo on around 500 or so entities as specially designated global terrorists, but then in addition to about 45 groups that are labeled as foreign terrorist organizations. Both of those types of decisions are executive branch decisions which are subject to review by the courts. Hamas, as we sit here, is both an SDGT and an FTO. And it's been that way since early 1995, well before Hamas was able to take over the ostensible government of the fledgling Palestinian Authority. I think it's important that we don't capitulate and cease referring to groups as terrorists just because they win elections. If we were to do that, Hezbollah likely would not be a terrorist organization today because they control a significant block of the Lebanese government. We have state sponsors of terrorism, in addition to the specially designated global terrorists and FTOs. But until Hamas and Hezbollah lay down their weapons and become true partners in some sort of peace process, like Sinn Féin arguably did in the Good Friday Accords, I think you'd have a lot of opposition among the U.S. foreign policy apparatus to any idea of de-designating them. That's my sense. And notwithstanding the fact that they have won elections in both Lebanon and in the Palestinian Authority.
We need to stop here. We will take a 10-minute break. And I would ask you to join me in thanking the panel for its